A woman in Ohio filed her marriage-based green card case 18 months ago. Real marriage, clean record, solid paperwork. Back then, cases like hers usually got approved by mail. No interview, no drama, card shows up in a few months. Instead, she just got a notice. An officer wants to see her in person, ask about her relationship, and go through her file line by line. Nothing about her case changed. What changed is everything happening behind the scenes she never knew about. Three things are quietly reshaping how USCIS reviews every green card case right now, and almost none of it made headlines the way a new law would. Start with the interview itself, because the shift here is bigger than most people realize. During the early 2020, USCIS waived interviews constantly for well-documented marriage cases. Modern Law Group and other firms tracking these cases reported waiver rates above 90% during that period. That era is over. USCIS's own 2026 policy manual update dropped the marriage-based waiver rate to somewhere between 6 and 9%, according to Atlas Legal Immigration Law's review of the current guidance. Read that again. 9 out of 10 marriage-based applicants who used to skip the interview entirely are now sitting across from an officer. Employment-based filers aren't fully spared either. About 72% still qualify for a waiver, which sounds fine until you realize that's still more than 1 in 4 employment cases now getting called in where they never used to be. Here's where it gets worse for anyone walking in unprepared. These interviews aren't a formality anymore. According to guides from multiple immigration law firms tracking 2026 cases, marriage-based interviews now routinely separate spouses and question them individually, often lasting anywhere from 20 minutes to over an hour for anything that looks complicated. Officers aren't just confirming what's on paper. They're checking whether your live answers match a file they've already studied closely. And that brings us to the second shift, the one almost nobody's talking about. If any part of this sounds like it could touch your own case, go ahead and subscribe now, because we're tracking exactly how these three shifts keep evolving through the rest of the year. For years, your immigration records lived in separate systems that barely talked to each other. A visa interview note here, an old petition there, a border entry record somewhere else entirely. That's changed. Immigration attorneys have started noticing officers pulling everything onto one screen. Every filing, every consular note, every prior application, side by side, cross-checked against whatever you're filing today. An old approval used to settle a question permanently. It doesn't anymore. If your job title shifted between filings, or a past visa denial never made it onto a newer form, that gap gets noticed now in a way it simply wasn't a few years ago. There's a fix, and it's simpler than it sounds. You can request your own immigration file through a FOIA request, and your consular records separately from the State Department. Lay them side by side before an officer does. If something doesn't line up, don't wait for it to get raised against you. Get ahead of it in writing, with an attorney, so a small inconsistency stays a small inconsistency, instead of turning into a credibility problem that colors everything else in your file. Picture that same woman from Ohio again, sitting in that interview room. Her officer already has her old visa application open on one screen and her green card petition open on another. One says she works in retail. The other says, marketing coordinator. Nobody lied. She got promoted 2 years ago and never thought to explain it anywhere. In 2022, that gap would have gone unnoticed. In 2026, it's the first question she gets asked. Now here's the part that catches even people who've done everything right. Social media screening used to stop at you. As of February 11, 2026, USCIS is authorized to collect social media and messaging information, not just from applicants, but from their family members too, under a rule confirmed by the Immigrant Legal Resource Center. That means a relative's public post can now become part of your case file. A parent celebrating your engagement online the same week you entered on a tourist visa. A sibling's caption that doesn't quite match the timeline in your petition. None of that used to matter. Some of it can now. The instinct here is to panic and start deleting. Don't. Immigration attorneys warn that a sudden wave of deleted posts or vanished accounts can read as evidence of hiding something, and deletion rarely works cleanly anyway. Screenshots and cached copies tend to outlive the delete button. The safer move is a quiet audit instead. Go back a few years across your own accounts and have an honest conversation with close family about what they've posted too, since officers really are looking at both sides of that picture now. This isn't limited to marriage cases either. Employment-based filers, family petitions, even naturalization applicants are seeing pieces of this same expanded scrutiny show up in their own files, according to immigration attorneys tracking the pattern across case types in 2026. The common thread isn't the visa category. It's how much of your life outside the paperwork is now considered part of the paperwork. Put these three shifts together, and the pattern becomes obvious. None of them required a new law. Interviews came back through a policy manual update. Records got cross-referenced through better internal systems. Social media expanded through a single rule change in February. Nothing here required Congress to do anything at all, and that's exactly why so few people saw any of it coming until they were the ones sitting in the waiting room. There's a version of this story where none of it matters to you. Clean record, consistent paperwork, nothing to explain. If that's genuinely your situation, an interview is still just an interview, longer than it used to be, but not something to dread. The risk was never really about having something to hide. It's about having something unexplained, sitting quietly in a file you assumed nobody would ever compare line by line. That assumption is the one thing that stopped being safe in 2026. If a case is sitting in your pipeline right now, pending, freshly filed, or still just something you're planning, the honest move is to treat every part of your history as visible, because at this point, most of it already is. Talk to an attorney before the interview notice arrives, not after. This video is for general information only and does not constitute legal advice. It reflects USCIS policy manual updates and reporting from immigration law firms and the Immigrant Legal Resource Center, current as of 2026. Every case involves different facts. Speak with a licensed immigration attorney about your own filing. Subscribe for the next breakdown, because these three shifts are still moving, and the next update might land closer to your case than you think.